making you see it. Streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces to stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Places tell.
Good morning, everybody. Good morning, good morning, good morning, good morning. Ooh, finally, we're getting some actions with these cases, y'all. Finally. I wanted to give you guys some update in regard to Lacy Boles' case. Oh, remember that juror, y'all? That juror that caused a mistrial? Well, that juror has to go before the judge. And this is a contempt to show cause hearing for that contempt. Now, let me tell you what this juror could be facing. This juror could be facing up to $1,000 fine and also one or the other, we don't know yet, and 20 days incarcerated in jail. This is what that juror is facing. But let me tell you something. The judge that did the mistrial, Chief Judge Bushi, he's not going to be the judge to do that. He decided to recuse himself. Recuse means to remove himself from that so he doesn't seem biased or anything like that. So he pushed it over to the county, to the clerk, and the clerk did a random selection. There's not that many judges there. Well, that judge that is going to be doing this is Judge, we're going to see it in a minute. Okay, you guys ready? Here is the notice of intent for the to show cause. All right, let's go. All right, here's the order set by the judge. Let me remove this off the screen. Hold on. Let me remove this off the screen. You guys, good morning, everybody that's coming in. I'm sorry I didn't get a chance to say good morning to everyone, but I just wanted to get ahead and get into this. And so we can go ahead on and then we can talk our little trash talk after a while. But right now, I just want to give the information out to you guys in regarding to this case. And we got other things to talk about, the motion that Mr. Steele submitted, as well when trial's going to start, how long it's going to be, those type of questions, okay? What's going to happen next? Because I need to give the update because you guys know we're going to be there, all right? All right, so it says, State of Georgia versus Lacy Boles, and then it gives a case number, right? Show cause order. The above matter was called for trial on June 15, 2026. On that date, the undersigned judge instructed the assembled jurors in the jury assembly room to perform no investigation of the case and do not discuss the case with others. So remember, the judge said no investigation and don't talk about it, right? And what did that juror do? The juror went and looked for it in ChatGPT. So he's in violation of two orders, two parts of this particular order that the judge did. Because once you swore in, because you know they have to swear in, right? And then once they swear in, they go before and they do the voir dire or voir dire, right? And they ask questions, and he was going to be moved to the next segment of the striking because the state wanted him. Because remember, I told you he's the one didn't feel comfortable and felt that she may be guilty, right? Remember that. But then he did say that he can be impartial, right? But then he went and investigated by pulling up ChatGPT, and then he said, ChatGPT says she's guilty. You hear that, right? Okay. All right. Thereafter, on day 2 of jury selection, Chief Judge Deputy Clerk Lori Jennings informed the court that juror number 18, Bobby Darrell Presley Jr., violated that directive. The court called Mr. Presley back into the courtroom where he was questioned about that allegation. Thereafter, both the state and defense moved for a mistrial, which was granted. You guys hear that, right? The mistrial was granted. Why? Because he violated the directive of the judge. The judge says for you not to do any investigation. The judge also said for you not to talk to others about the case, which he did. He showed them the ChatGPT investigation thing, okay? So he violated the judge thing. So now this is the next step, okay? The show cause order. The undersigned judge voluntarily recuses himself from this contempt proceeding, but does not otherwise recuse himself from the above referenced criminal case. It's just saying that the judge decided to remove himself from this show cause hearing, so it doesn't show any kind of impropriety or anything like that. So he moved it over to the clerk, and the clerk is the one going to do a random selection of a judge to do this show cause, okay? The clerk of court shall randomly assign another superior judge to hear the contempt proceeding, and a hearing will be scheduled on the judge's next available criminal motion calendar, which is at least 2 weeks, 14 days out, okay? Bobby Darrell Presley Jr. shall appear before Judge Lyles in Courtroom 3, Superior Court, Paulding County at 9 a.m. on the 11th of August. Ooh, child, y'all. I got to run over there because, you know, I'm going to be at the Sarah Grace trial, right? So I have to go. I'm going to go here first, and then I'm going to travel back over to Sarah Grace's trial because that's the trial I'll be on. Sarah Grace's trial starts on the 3rd of August. I told you guys I was going to be there for the whole trial. So I'm going to be there. So it's not, I got to figure out how far Carroll County is from Paulding County. I don't think they're that far from each other, but it's going to be, me maneuvering over. So I don't think the show cause is going to be that long because he's going to testify. He's going to probably bring his attorney there, and his attorney going to be standing with him. Hopefully he has an attorney with him. And he's going to discuss why he did what he did. And then the judge is going to make a decision whether to hold him in contempt and what is it, if it's going to be a fine or if it's going to be jail time or if it's going to be both. That's what's going to be talked about. Okay, but the judge is going to show cause. He's going to have to explain to the judge why he did what he did. I don't know. It's just mostly about how much, what kind of consequences he's going to receive. We're going to see based on his explanation or excuse. The judge is going to make a decision of how much, he's going to be held in contempt some kind of way, because there's no way, because they spend so much money to try to get all this jury together. They did 3 panels of jury already, and they were getting ready to go through the striking part, which he just took the whole case and just caused it to be a mistrial. So that's a problem, because that was money spent. That was time taken. There was other jurors having to get through this. There are more to this case because her stepdad, hold on a second. There is more to this case because her stepdad is a retired detective of Cobb County and her grandfather is the president of the South Union. So now after doing some investigation, okay. Jim, hey Jim. Jim is relative to Daniel. Jim is Daniel's relative. Good morning, everybody that's coming in. Good morning, good morning, good morning. Thank you, Jim, for that information. Y'all, we have our own close people to this case that comes in and tell us certain things. So shout out to Jim this morning. So this is going to be on the 11th of August. I will be there to show cause. Hopefully, Law and Crime or whoever is going to cover this. We don't know yet, but I'll reach out to them and find out if they will be covering this part, this show cause. We'll see. I don't know. They may not. A local news might do it, but I'll be there. If nobody else is going to be there, I'll be there, y'all. So the potential, it says that show cause why he should not be held in contempt of court for performing and sharing with other potential jurors research on this case in violation of court order. So he has to show cause of why he should not. And he says a copy of this was sent over to him, and this is it was done on the 29th of June. Okay, so that is the show cause situation with that juror. So we will see what happens with him. It's not cool. I find that blue thin line. I find that blue thin line I always hear about. They protect each other. I concur on that one, Jim. I concur. They definitely protect one another. I tell you that. I definitely believe that. Okay. All right. Now, the next thing is we want to know what's going on when it's trial. And I found out the trial is going to be November the 9th. The 9th of November. Let's go ahead on and look at that. Let's look at the judge's order on that. Okay. Hold on. I think this is it. All right. Here's the judge's order for. Can you guys see this? This is the rescheduling order of the trial. Okay. All right. It says the order rescheduling specially set trial. It says the above style criminal case was specially set for trial the week of June 15th, 2026. Following an improper conduct of a potential juror, the state and defense jointly moved for a mistrial, which was granted. The trial is hereby reset as set forth herein. It is ordered that the above referenced criminal action is scheduled for jury trials to begin 8:30 a.m. Monday, November 9th. The trial is expected to last 2 weeks. So now you guys know the trial is supposed to last about 2 weeks. Okay. And it says here, the deadline for filing any kind of motion is expired, so you don't need to do anything with that. It has passed. Pretrial hearing for all potential motion was conducted on June 2nd, that's done. If either side believe there is a matter of such importance that it must be taken up by the court in advance of the trial and would require such time that it may delay the start of the trial, you may contact Judge Bushy, Judicial Assistant Amy, I don't want to butcher her last name, regarding scheduling a hearing. The the court has decided against using jury questionnaire again. Proposed void dire question must be in written and submitted to the court no later than 5 p.m. Wednesday, November 4th. So they have to do a new set of questionnaire, y'all. You need not copy oppose. You need not copy opposing counsel when submitting your questions to court. Rather, on the date of trial, proposed question will be exchanged and the court will make its ruling outside the presence of the jury. So they're going to do, they don't have to submit the questionnaires to each other. The judge is going to have them to talk about it, outside the jurors. They're going to do it in the morning, okay? The question must be limited to the scope of the OCGA 15-12-133, Uniform Supplement Court, whatever that thing is. And so there it is. The trial will start on November 9th at 8:30 a.m., okay? All right, so that is that. Okay, we have a motion that was submitted by Mr. Steele. And let's discuss this motion. It's not much, but it kind of it's something that they're requesting. They're requesting some stuff. Okay, I believe that the Brotherhood has covered up the importance of this case. The Brotherhood, as far as the blue blood, you mean the police department? That's what you're talking about, right? Police department? I mean the sheriff and police and all that. That's what you're talking about, right? All right, let's go ahead on and see the motion that Mr. Steele submitted for, okay, the police. Okay. Jim, one of the witnesses that, remember I played the video, the audio recording of, not the audio, the the hearing. I could play it again. Hold on, let me play it again so I could show you what I was talking about. Hold on. He didn't want to show up to court because he said that, hold on a second, let me just take this out. He said that some stuff is going on in that courtroom. Hold on a second. Hold on. Sorry, y'all. Sorry. He didn't want to be no part of it. Remember? He said something about that. And he was saying the Masonic stuff. He said that certain things happen. Remember when I was talking about that? Hold on. Let me see if I could play that. I think it's on here. Hold on a second. Let me just show you. Hold on a minute. Let me show you Mr. Steele's thing first, and then I'll go ahead on and play that part. Jim is distracting me here. Jim, I'm gonna get you. All right, hold on. All right, here's Mr. Steele's motion. All right, let's see. Let's make this a little bit bigger. All right, here's the motion. The motion to use transcripts as an aid. To use transcript as an aid. Yes, you could miss. Okay. Hey, Keith, good morning. Good morning, everybody that's coming in, everybody. Good morning, good morning, good morning. All right. Now comes defendant Miss Lacy Boles by and through undersigned counsel and hereby file this motion to use transcript as an aid in the above referenced case. In support of this motion, Miss Boles shows as follows. 1, Ms. Boles is innocent of all crimes in the above referenced indictment. 2, Ms. Boles respectively requests that this honorable court to permit the use of the below attached redacted transcript as an aid during trial. 1, oh my God, I can't even say the word. Number 1, okay? Transcript of 911 recording of on December 22nd, 2019. Transcripts of Ms. Boles' statement to law enforcement on December 30th, 2019. Number 3, transcript of Ms. Boles' statement to law enforcement on January 7th, 2020. Number 4, transcript of Ms. Boles' statement to law enforcement on March 5th, 2020, part 1. And it says here, number 1, these redactions were made by Ms. Boles' counsel. However, Ms. Boles respectively requests the prosecution and anyone else to review the same to ensure the redaction comply with the order of this honorable court. Number 5, transcript of Ms. Boles' statement to law enforcement on March 5th, 2020, part 2. Transcript in this case are needed to permit the jury and assist them in listening to the recording. The transcript is not evidence, will not go out with the deliberating jury and act solely as an aid. Baker versus State and gave a case number. Rashid versus State gave a case number here. This honorable court will be requesting to instruct the jury that the recording is the evidence and the transcripts are only an aid. Number 4, based upon information and belief, the prosecution is objection to the use of this transcripts. Said transcript. Wherefore, Ms. Boles respectively requests this honorable court to hold a hearing on this motion and at the conclusion of the same, ask this honorable court to grant the above requested relief. The 25th of June, 2026, respectively submitted Brian Steele, and then he gives his law firm. So he is asking the ability to use the transcript of those 5 items to use as an aid for the jury to be able to understand, because the audible might not be too clear. So they had a transcript for the what is being said in that recording, because sometimes the recording has a lot of background noise and stuff like that. It's hard to hear, hard to understand. So they want them to be able to read what is being said on that transcript, just to aid them in that. But it's not going to go back into the deliberation room with them. It's just going to be used as an aid for them to understand if there's not clear or it might be muffled or something, so they'll be able to hear that. Okay. So, but the state is objecting to it. So Mr. Steele wants the judge to have a hearing on whether or not to be able to use it as an aid. Okay. So most likely they're going to have a hearing, during trial, before the jurors are seated, just to get the final decision from the judge. Any question? All right, now back to what we were talking about. I think Jim made a comment in regarding to people protecting themselves, and it came to mind about that witness who was an ex-sheriff employee. Well, he is being called as a witness, and he does not want to testify. And I think I have the hold on a second, y'all. I have the remember the hold on a second. Hold on. I have the during the trial there was a hearing done, and this is when the officer said he didn't want to. Oh no, this is the hold on a second. Is this it? Hold on a second.
Yesterday afternoon is the first indication we had that was interested in negotiating plea. And
okay, hold on a second. I'm trying to see when. Oh, I thought it was in here.
yesterday afternoon is the first indication we had that.
I'm trying to get that last one. Hold on. Okay, this is not it. Okay, it might be in here. It's in here, y'all. Hold on. I gotta go to the clippings. Okay, I think it's the last one. Yeah, hold on. Not this one. I thought it was 186. Was it this one?
Would it be easier for y'all if we just copied that and gave that for you? Okay. So then it's the purposes. Investigation, I knew I was going to talk to
Okay, I'm trying to find out when there's the.
All right, I think that is today. I'll get y'all out in order as soon as possible. Potential problem we have a juror that feels strongly about it, and here we are telling her. Can I talk to y'all about schedule?
No, just for the record, can I not submit? I'll do whatever the court says and the prosecutor desires, but instead of bringing the thumb drive, we'll just copy the disc and the papers or the I don't know, put the onus on the court to copy the disc so I can have.
Here for y'all, if we just copy that and gave that
Purposes of today.
okay. So then,
I want to.
Yes, that's just some housekeeping matters. I have a thumb drive here, Your Honor.
I haven't really fully grasped.
Oh gosh, I got
Just, I felt like I had enough at that moment just to.
I think I have it on audio only. I thought it was an actual recording, but it's the audio. Then I gotta pull it up. I gotta pull the audio up. Hold on a second. But in the meanwhile, let me go ahead on and play this as a reminder of the case. Hold on, let me bring this up so you guys can watch something while I take care of this part. Hold on. I'm just gonna give you guys something to watch for a minute.
And because Lacy had been transported to the Walton County Hospital, once I made sure that the scene was secure, I didn't left for the hospital.
And you left for the hospital. Why did you go to the hospital?
That's where Lacy was taken to by EMS in an ambulance.
And what was your purpose in going to the hospital where this defendant was?
to talk to her to see if she'd tell me what happened that night. And also, I had a consent to search paperwork that we have with the sheriff's office that I was going to see if she would sign so we could finish with the house.
So when you left, there was still law enforcement on at the house scene, is that correct?
Correct, yes, sir.
And you leave that scene and you go to the hospital where this defendant is.
Correct.
Okay, so now you're at the hospital. What happens now?
I locate, I'm shown where Lacy is in that room by hospital staff. I go in and she is sitting, I guess it's like a table or whatever type of chair they have in that room, in the hospital room. And there was another male and female, which I believe she had told me was either her daughter, her boyfriend, or maybe his sister, her boyfriend. I can't remember exactly who was who on that. But there was a male and female in the room.
And she was in the room. So 3 people were in the room besides you, is that correct?
Correct.
So when you entered the room, what, if anything, did you do?
She was emotional. She was crying. I told her who I was, and that if she could tell me kind of what happened that evening, that morning, and she went through and told me. So at that point, I went with the consent to search. I had filled out the first initial part, which is just basically putting the name, her address, who I am. The other detective was doing Amanda Carter on the scene. She was a crime scene person, and that basically you're giving me permission to go into the house and collect anything that is related with the incident.
Now, you're on the scene and you're talking to this defendant. Did you have any trouble communicating with her at all?
No, sir.
Did she have any trouble communicating with you at all? Officer Ogden, I show you what has previously been marked for identification as State's Exhibit number 5, and ask if you can identify that document.
Yes, sir. This is the consent search form.
And is that in fact, the consent form that you presented to the defendant on that day?
Yes, sir.
And this is now December 22nd that you're talking to this defendant. What did you tell her about this consent form?
So basically, I filled out the initial portion, which is Lacy Boles. It goes into it, and it comes into myself and Detective Carter, who are all the county detectives, and doing a complete search of the premise at 83 Braden.
Okay, now, I want you to tell this court exactly how you went over that particular document with this defendant on that particular morning. Just exactly what you did with that document.
So I basically read the entire document.
Okay, can you read the entire document as you read it to the defendant that morning?
Yes, sir. So I, Lacy Boles, have been informed of my constitutional right not to have a search made of the premise and or automobile mentioned without a search warrant. I have also been informed of my right to consent to such a search. However, I hereby authorize Detective T. Ogden and Detective A. Carter, Fulton County Detectives, title of officers and agents, names of agency, to conduct a complete search of the premise and or automobile at 83 Braden Court, LS 30157. These officers or agents are authorized by me to take from the premises and or automobile any letters, papers, materials, or other property which is contraband or evidence in the nature of suicide. I understand that this contraband or evidence may be used against me in a court of law. This written permission is being given by me to the above named persons voluntarily and without threats, duress, or promises of any kind. I understand that I may ask for and receive a receipt of all means stated.
And did she in fact sign it?
Yes, sir, Chief.
Did you watch her sign it?
Yes, sir.
And at the time she signed it, was there any type of duress or coercion to make her sign it?
No, sir.
Did she have any questions at all about that document?
Not that I recall. No. No, sir.
Well, if she had any questions about him, what would you have done?
I would have answered the question.
Okay, and if she had a problem understanding any of it, what would you have done at that point?
I would have stopped with paperwork, if she's not understanding.
So you were content from talking to her that she understood what was being said and what the document said?
Correct, yes, sir.
At any point that morning, did she ever convey to you that she in any way wanted the search limited in any fashion of her home there at Brainmill?
No, sir.
Brainmill Court, okay. At any time did she say, hey, you know what, I thought about it, I want to stop this search? Did she ever indicate that?
No, sir.
Was this a result of any kind of prolonged questioning that you gave her that day?
No, sir.
How long do you think you talked to her about giving this particular consent on that morning?
I may have been in there 20, 30 minutes.
And if she had any questions, did you answer them?
Yes, sir.
Was she threatened with any type of physical punishment to give you consent to search?
No, sir.
And were you able to tell her approximate age by looking at her?
Approximately, yes, sir.
Okay, how old did you think she was just by looking at her?
Probably late 20s, early 30s, somewhere around that.
Okay, and did she seem like she had normal intelligence when you were talking to her?
Yes, sir.
What about her education? Did she seem to understand the English language all right?
Yes, sir.
And was she in detention at all when she talked to you?
No, sir.
And was there any type of fear or intimidation used to get her to talk to you?
No, sir.
And was there any kind of threat at all to obtain her affirmative response to your request for a search of her home?
No, sir.
So the question for the way. Officer Ogden, when you were talking to this defendant, did she give any indication that she did not understand what was going on?
No, sir.
Did you see, well, let's just talk about this. Have you seen somebody under the influence of intoxicants before?
Yes, sir.
Did she give you any indication that she was under the influence of intoxicants to the degree that she couldn't comprehend what you were saying?
No, sir.
And any question she asked, was it an appropriate question to you from what you were advising her on?
Yes, sir.
And if you had any indication that she was not able to comprehend what was going on that particular morning, what, if anything, would have been your response to that?
I would have ceased communication at that point. I felt like she wasn't understanding.
Did she ever tell you, hey, I don't want to talk to you at this point?
No, sir.
And was she cooperative or uncooperative with regard to what you were asking for?
She was cooperative.
That's all the questions I have. She's with you. Oh, sir.
Were you wearing a body-worn camera or any type of recording of this interaction with Ms. Boles?
No, sir.
Was anybody, to your knowledge, that recorded this interaction that the court can have?
No, sir.
So, do you know whether there was any type of medical drug, prescription drug given by the medical personnel to Ms. Boles before you met?
I would not have known that, sir.
Now, when you arrived at the house, Ms. Boles' home, deceased home,
Yes.
do you remember seeing Ms. Boles being helped out, escorted out by the EMTs?
Yes, sir.
And can you tell us what type of condition she was in at that time?
She was very emotional, screaming, crying as they were taking her to the ambulance.
And then I believe you went into the home. You didn't go with Ms. Boles to the hospital. You didn't go.
Correct.
You went into the home,
and you saw the deceased, is that fair to say?
Yes, sir.
And what was going on when you first went into the home? You saw the deceased in that home?
I believe there may have been a deputy. I couldn't tell you exactly how many. There may have been 1 or 2 deputies in there that were just there to secure that scene. But other than that, that was it.
How about the EMTs before? You don't know what they did because you got there later.
Correct that, I don't.
All right. When you go to the hospital, Fulton County Hospital, you met with Ms. Boles.
Yes, sir.
And you knew that by the time you got there, she had cleaned up, she had blood on her hands when she was leaving the house, and she had no blood on her hands when you saw the hospital. Is that
Yes, sir.
what you remember it?
Yes, sir.
And she was still extremely emotional, whatever the right word is, when you saw her in the hospital.
Correct. She was still crying and just in an emotional state.
Similar state when she was being escorted out.
Not as loud, if that makes sense.
Yeah. And in fact, you gauged it where you didn't think it was appropriate to interview or interrogate Ms. Boles at that time, in that state of mind. Is that
Correct. After I got her initial just brief of what happened, at that point, I just went to the consent search and just decided I could talk to her at the time.
And why was that? Why did you think it was appropriate to
Just the,
interrogate her? It's probably me I'm talking to, so the court reporter probably was one of us at the time. Can you tell us why it was that you made the decision that it was not appropriate, it was not fair, whatever the right word is, not just settled, not reasonable, interrogating Ms. Boles at that time? So that's my question.
basically, the gist of what she told me, I kind of had an idea with her statement to me at that time. At that point, her emotional state, I felt like there was no need to press forward. She kind of told me the gist of everything that had happened. So at that point, I wanted to at least get the consent search of the home.
What did Ms. Boles tell you about the incident?
She told me that she had heard the deceased come in the house, and at that point she had followed downstairs, and then when he entered the room to the left, once you go downstairs, she said that he had turned around and she saw that he had a gun, and she said, "What are you going to do? Shoot yourself?" And then I guess at that point she said he had shot himself, and then she fell on top of him trying to do CPR.
Did she tell you she tried to stop the deceased from shooting himself?
Yes.
And then,
Hold on. Did you guys hear what it? Wait a minute. Did y'all just hear what the officer said? Did y'all hear what the officer said? Jim, did you catch that? Is Jim around? Where'd he go? Did you hear? The officer said that she fell on top of him. I'm gonna replay that for a second because I'm kind of confused. Because remember, one of the motions that she set in, which the judge denied, was a motion of self-defense and the immunity hearing. Remember the immunity hearing? I listened to it 10 more times or more. You remember when I was telling you guys there was an immunity hearing? And the immunity hearing was a self-defense, right? You guys remember? Are you guys listening to what I'm saying? I'm just providing information, y'all. I'm not making any conclusion. I'm just giving you guys information based on what's in the document, okay? You guys come to your own conclusion of certain things. I'm just giving you guys information, neutral stuff that's in the court documents. That's all I'm giving you guys, okay? I'm not a jury. I'm not a judge. Just giving y'all reporting information, okay? All right. But I'm you guys, I'm trying to put 2 and 2 together here, and I'm just not. It's not clearing. It's not clear for me. Okay, it's not. It's not clear. It's not. And this is going to be a judgment based on the jury. Okay. All right. Let's go ahead on, and I'm going to replay this part again, and all right.
She fell on top of him trying to do CPR. He saw that he had a gun, and she said, "What are you going to do? Shoot yourself?"
She said, "What you going to do? Shoot yourself." She saw he had a gun. What you going to do? Shoot yourself, right?
And then I guess at that point she said he had shot himself. And
he had shot himself. At that point, he had shot himself.
She fell on top of him trying.
She fell on top of him trying to what?
To do CPR.
Trying to do CPR. Did he say CPR? She fell on top of him trying to do CPR? Hold on.
He had shot himself, and then she fell on top of him trying to do CPR.
Okay. She said she fell on top of him trying to do CPR. How do you fall on top of somebody trying to do CPR? Either you get down on the ground to do CPR, but how do you fall on top of him? I'm confusing that statement. You fall on top of him trying to do CPR. Is she explaining why the blood is all over her, or is that explanation, or just a question? Just a question.
Did she tell you she tried to stop the disease from shooting herself?
Yes.
So now Mrs. Steele asks, so she said she tried to stop him from shooting himself. And then he says yes.
And then after that was when you did the consent to search. Before that conversation, you did the consent to search. Do you remember?
So then after that, after that conversation, did you do consent to search? Consent to search.
But it was a conversation first, and then consent to search.
Okay, there was a conversation first, and then there was a consent to search. So he had a conversation with her, and then he produced the paperwork for him to go and get a permission to go search the home.
And after speaking with her is when you realized I should not be having a conversation with her, a full conversation. Correct. What was it about your interaction at that point with Ms. Boles when you said this is not the time?
Just the emotional speed. She would be able to, she'd be crying, she would stop, she could tell me what happened, and she'd start crying again. So I felt like at that time, not really knowing much, but I had a death investigation, I didn't feel like pressing her, not knowing exactly.
He didn't feel like pressing her because she would cry, she would stop while he was asking a question.
What happened.
And then you read to Ms. Boles, you let her read the consent to search form, which I think you could check it from the state's exhibit number 5 for purposes of today's hearing, but I may be wrong.
Yes, sir. I did, basically, like I said, I filled out the top portion of her name, my name, the other Detective Carter, all the county detectives, the address, and the nature of suicide. And and I signed my name, and she signed her name.
Did you read it? Did she read it? Do you remember?
I read it to her.
Okay. I don't see a time on State's Exhibit number 5. Do you record the time by any chance?
The time I did not say.
He didn't record the time at the time of putting that consent thing. He didn't put the time. They recorded the time.
I don't believe I heard the question. I just have a moment.
Yes,
You're out there for a moment.
yes, sir.
Thank you, sir.
Well, first of all, your state tender's number 5.
Any purposes of today, no objection.
All right.
Mr. Steele was asking you the questions about you not continuing to question this particular defendant at this particular time. Did you quit talking to her because you couldn't communicate with her, or for some other reason?
Just another reason. I felt I had enough of an initial statement from her, just kind of the gist of what had happened that night. Obviously, being this a death investigation, I knew I was going to talk to her at a later time, and I still hadn't really fully grasped the scene yet. I just had a quick glance, kind of just talking to the other officers on scene of what had occurred, what they had responded to. And so at that point, I felt like I had enough at that moment just to begin the investigation.
That's all the question I have. Thank you.
Anything else for this witness?
Your Honor, we don't.
Thank you, sir. You step down.
Yes, sir.
Your Honor, state risk.
All right. Is there any other evidence on this motion? No?
No, Your Honor, state risk.
Not on behalf of Ms. Boles.
Okay. Any argument y'all would like to
Okay, I can submit with that argument. That's not a concern.
make? All right. All right. So we now at the point where we've covered all of the pending pretrial motions. Yes?
Your Honor.
Yes.
Just some housekeeping matters. I have a phone drive here, Your Honor, State's Exhibit 4. Stayed in my place as a member of the bar in good standing that this is the audio recording valid to see this phone that we talked about. I'd like to consider that and admit that into evidence. This concerns the state's motion on number 1 to have the court admit under audio recording evidence from a phone.
All right. Any objection to that, Mr. Steele?
No, not for purposes of today.
Okay. Submitted for purposes of.
And then ask for leave of court for the court to allow me to take the clerk, get the clerk to allow me to take possession of state's number 1. I'll make a copy of state's number 1 and return state's number 1 to the clerk tomorrow morning. Just need to maintain a copy of state's number 1 for trial. And also state's number 2, I'd like to make a copy and retain for trial state's number 2. That's the way to form. That's it.
Right now, the prosecutor is just asking for certain things. He's going to make a copy for trial. These are evidence, state number 1, number 2 that he's mentioning. I think 1, it has to do with the recording, the phone recording that the deceased had recorded, and the judge did rule on that. Certain things that will be able to be heard, only the parts that pertain to him and her having an argument, but stuff that he said in regard to a family member saying that she was cheating, that part cannot be brought in because that is considered hearsay. So they have to do some redaction of the recording. This is the one where they were trying to get for court. You know, I guess he had it in his phone and they had trouble trying to pull it out because of the password protection and all that. It took months for them to even get that. So that's basically it on this. But I did get a chance to pull the recording of him, the prosecutor stating that there was someone that did not want to come to court, and it was one of the sheriff who said that basically, if you call me, you're not gonna like it if you call me, because I may mess up your case, because I don't want to be in that demonic place, because all of the stuff that they do in the mason stuff. And so I'm gonna play that for you guys. Hey Miss Green Eyes. Hey Rob. All right, here we go. I'm gonna play that because I played this before, but I just want to play it as a memory to you guys. I think you guys like recaps of certain things, and just to keep you guys abreast of what's happening. Anybody that's coming in late, what I did talk about, I talk about the juror who violated the judge's order. He has a show cause hearing, which is going to be on August 11 with a different judge, because this Chief Judge Bushi recused himself, removed himself from the show cause hearing. So, but he has not removed himself from the actual trial. The juror will be before Judge Lyles. I plan on being there to give you guys information what happened and things like that. I will be putting my Rule 22 for that part, so you guys can get a chance to hear what happened in the courtroom in regard to that juror. Just for your information, I know some people want to know. He is facing the possibility of jail time and a fine, or just jail time or just a fine. We don't know what the judge is going to come down to. He's just going to have to find it. He's just going to have to explain why the judge should not hold him in contempt. I don't know what kind of information you're going to bring to the judge. You're going to have to bring a doctor's note saying that he can't comprehend certain things and he was not a good juror because he doesn't have comprehension skill. I don't know. I'm just saying. When somebody said don't do it, you're not supposed to do it, especially when you sworn in that you wouldn't do it. I don't know. It's going to be rough on that one. So, all right, let me go ahead on and play the part where the prosecution was saying that there is a witness who says he doesn't want to come because he don't want to participate inside that demonic place. All right, let's go.
Text this morning, I am not going to be a good witness because I want nothing to do that takes place at that courthouse. And that's where I have a problem, because it seems to be telegraphing to me, you don't want to call me because I don't want to be there anyway. And that's a real problem, because we have a right to call him, just like the defense has a right to call whoever they want if they choose to call anybody at all. But you cross a line where you almost barely send a thinly veiled threat. You don't want to call me because I don't want to be there anyway. And I don't know that some court wants to address him personally before he gets called, or I just want to put him in your arena and let you be thinking about that possibly. He's been really reticent to come here because this building is associated with the Masonic Lodge.
He said the building is associated with the Masonic Lodge. He does not want to be part of this because all the demonic thing that goes on in that type of organization.
He's no longer with the sheriff's office, but like I said, Judge, logistical problems. Personal scheduling, things like that will work with me across the line when you're working out. And I'm not going to be able to witness for you because I don't want to be there anyway. And I really would ask that you all do respect consider.
He's asking the judge to speak with this dude. And the judge basically gonna say, there's nothing I can do about it, you know?
Understand your religious beliefs and everything like that, but you cannot sit here and tell somebody that you're going to take their case because you don't want to do it. That's a real problem, especially for law enforcement officers. So that's what
He's basically saying now it's like, you can't say something like that you're going to ruin the case. And this is an ex-police officer. So he's having trouble with his own witness. His own witness is giving him trouble.
Should we have a copy of all the correspondence?
Mr. Steele is asking for copies of the correspondence between him and that witness. And the prosecution agrees to give it to him, but he also said it's really not anything against you, it's against the state.
Showing the correspondence and the bias and the motive seems to go
Right,
against the state.
I'm sorry, go ahead.
The bias and motive would go against the state for calling him, he's mad at us, and I'm glad to show it in the speaker.
Well, I certainly am concerned about it. Testify, people didn't let testify. Sometimes they got a feeling that they're trying to exaggerate. So it happens. Not quite sure what the remedy is.
Judge is basically telling him he's not quite sure what the remedy would be for you with this dude. I don't know. What would that remedy be? Because if he doesn't show up to court, he's going to be held in contempt and he's going to have to show cause and all this kind of stuff. But as far as him, when he get on the stand or what he's going to say, you can't really control what the man says. Yeah. As long as he get on there to tell the truth, the whole truth, and nothing but the truth, there's nothing they really can do. Now, if he could say something, say something that's just outrageous. They could say, I object, that type of thing, and then move on. But they can even make a ruling saying that he is he's uncooperative, not replying, or something like that. I don't know. But he can't really do anything once he gets on that stand. He just want to make sure this dude don't mess up his case. So I don't know. He wanted the judge to put some sort of threat. I don't know.
Think about it over lunch. If you have a specific request for me, I'll consider it.
Oh, but the judge did say, if you have a specific request for me, I will consider it. A specific request. So he might ask, I don't know, specific request. I don't know. But he did say he'll look at it. So, but that was it, y'all. That is it for the Lacy Boles update. I gave you guys the next court trial is going to be November 9th at 8:30 a.m. Same Judge Bushi. And the show cause is going to be August 11th at 9 a.m. and Judge Lyles. And Mr. Steele submitted a motion to be able to use the transcript of those 5 items, the interview, the 911 call, the interview from the 2019, the 2 interview 2019, one interview for 2019, which was done on December 22nd. Then the interview on March 5th and the interview in January 19th, yeah. So, and there were 5 items. They did a transcript printout, and they want to give that to the jurors to be able to help them as an aid, but it's not going to go back in the deliberation room with the jurors. So it's just going to be used as an aid, and that's it, not for evidence to go to the back. Okay, so that's basically it. That's all I have for you guys. I will be discussing the Sarah Grace in a few minutes after I come back. But anybody have any questions? Any question? If not, I'll see you guys in a few. I'm gonna go to my other channel because I have some, not some regular stuff to talk about. I'll talk to you later. All about court cases on this channel. The other stuff is for the other channel. I'll see you guys later. Love y'all. Bye.
Thank you for watching the infamous Sylvia channel. Well, pick up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click